Thank you very much. So by now, ladies and gentlemen, you have figured out that I am not only your host for today, but also your master of ceremonies. After all, we're on some budget-cutting exercises, and I think it quite useful to double up capacities in the circumstances. So my first order of business is to express a very hearty and warm welcome to all of you. This is an enterprise facilitated most kindly and importantly by someone who I describe as my boss, meaning my permanent secretary of the Ministry of the Attorney General and Legal Affairs, Ms. Ingrid Siratan, who has very kindly enabled, through the very excellent complement of people working at the AGLA, headed on the communications department and by Ms. Claxton, a very collaborative event today. And I would just like to say, as an opening statement, that this is intended to be a springboard exercise to carry forward discussion, because there are very purposeful plans afoot by the government. But plans are for naught if they don't have support and if they don't enjoy, at least starting with an intellectual acceptance and then a spiritual acceptance. And I put it at very basic terms because for far too long, the workings of the Office of the Attorney General has been kept behind closed doors in certain circumstances. And it is a very purposeful measure that we choose now to open the door into the workings of legislation and operationalization issues. Because if you intend to make laws and good laws for the people of Trinidad and Tobago, the rationale behind it has to happen. With us today is a very distinguished array of speakers, and you will no doubt recognize a host of persons sitting at the head table, at the floor, I should say, in our conversation type style, who I will introduce one by one as we come together. But the participants today are really carrying forward the exercise of bringing information into the public domain. I stand before you as the Attorney General of Trinidad and Tobago, and my purpose under the Constitution, apart from the parameters described there, is to act as an enabler for the laws of Trinidad and Tobago and to achieve efficiency in the measures that we put out. We have a host of issues that grip our country. Crime and criminality are a scourge that none of us can afford. It is an apolitical issue. For that reason only, a public forum such as this, not a forum which is on the floor of the Parliament or a joint select committee of the Parliament where rules of privilege prevail and where procedures are too tight, was chosen for this event. Open by way of participation included the opportunity for all members of society to step forward and contribute, including members of the opposition, who I had hoped would have been here today to carry on some of the discussion. It is with that purpose in coming to the public forum that this is going to be the starting point for a number of public consultations. We intend to move after opening the discussion on the prisons to springboard into the criminal justice system, and thereafter specifically to springboard into corruption, money laundering, and asset forfeiture. Those are the first three consultations we're having. The Attorney General's office has crystallized a public agenda for consumption, our legislative agenda. It will be published very shortly. We are just awaiting the final implementation of the National Risk Assessment. But having produced a public agenda, a legislative agenda, for the first time in 5 years, in 6 years, we can't drive legislation unless there is public support. We can't recommend solutions in a vacuum. And we can't agitate for societal acceptance unless certain things are made known. With those introductory remarks had, I've prepared a PowerPoint presentation. Actually, it'll be one of the first occasions that I would actually be speaking from a piece of paper in my entire public foray. But the reason that we've done this is that the legacy work that is being put out today is going to be hosted onto a website at the Ministry of the Attorney General and Legal Affairs, as will each of the contributions and the podcasts of the certain elemental contributions, so that people can access the statistical information that is now being put forward into the public domain. With that said, our prison reform consultation is intended, as the logo has said, to bring the pieces together. And permit me to dive into, if I can find where the actual base is. Okay, so the technology has to assist us this afternoon, and I'll start off by introducing the fact that the objectives of this particular reform consultation include to present an analysis of the prison system based on statistical and empirical data, to address challenges facing the criminal justice system, to outline proposals which the Ministry of the Attorney General and Legal Affairs and the Ministry of National Security, I should add, are engaging in treating with the challenges, and as I've said, to launch a web portal where the material can be accessed and contributions can be made from the general public. The encouragement of public discussion on issues drive what the required solutions are going to look like. Trinidad and Tobago has a prison system. Our prison system includes the fact that there are 8 prisons and 1 industrial institution. You would be aware that the industrial institution is now to be reclassified as we deal with the issue of children in the package of children's legislation, which is now before a joint select committee of Parliament. But of our 8 prisons, it's important to note dates of construction, capacity, throughput, and the plant and machinery appreciation. We have, of course, the Port of Spain prison, which was built in 1812. We have the Carrera convict prison, built in 1877. We have the Tobago convict prison, built in 1902. And then we have Golden Grove prison, built in 1940. Our remand prison was built in 1950. Our women's prison, built in 1970. Our maximum security prison, built in 1998. Our Eastern Correctional Rehabilitation Center, built in 2010. And our 1 industrial institution, built in 1949. Separate and apart from those 8 institutions and 1 other, we would note that the Immigration Detention Center houses prohibited immigrants, and that there are currently 130 male detainees and 30 female detainees, and that further there are 31 male detainees housed at the Eastern Correctional Rehabilitation Center and 9 female detainees housed at the women's prison. So there is an aggregation of the prison system comprising plant and machinery in the form of physical assets, and we house prisoners which fit into 3 categories, if not 4. Those 3 categories would be, first of all, persons who are detained at the instance of the immigration authorities. Secondly, persons who are incarcerated on what we refer to as pre-trial detention or remand. Persons who are convicted and are serving jail sentences whilst their process is going through or whilst awaiting appeal, but certainly after conviction. And then lastly, if we could subcategorize the host of children that are detained in our system as well. As you would know, that system is to be moved into, with the operationalization of the children's packages, into rehabilitation centers, and we are moving away from the concept of youth offenders. We're instead moving to the concept of child care and child management in pre-trial and post-trial issues. After all, there are children who are incarcerated, literally, for matters including things such as beyond control, badly behaved, but still nonetheless subject to detention. I thought it important to put forward into the public domain what our prison population looks like. And this information, I would add, is going to be available to everyone
by way of the web access and certainly to the media as well. We have, of the 8 categories, a total of 3,667 people incarcerated at present. At Golden Grove, built in 1949, the capacity there is 225. We have 90 people there, which is roughly a 40% capacity. That's the Youth Training Center. At Golden Grove, built in 1940, the capacity is 430. We have 287 people as of December last year, being a 67% capacity. The women's prison, Golden Grove, built in 1970, there are 50 out of 158 placements there, being a 32% capacity. The remand prison, built in 1950, houses 1,032 people as of December last year, where the capacity is 655, totaling to a 157% occupation. Maximum security prison, built in 1998, has a capacity of 2,453 spots and 971 inmates as of December last year. Port of Spain prison, built in 1812, has a capacity of 250 people and houses 725 people. In other words, 290% occupancy. Carrera Convict Prison, 1877 it was built, capacity of 185, housing 201 persons, therefore having a capacity of 108% occupancy. The Eastern Correctional Rehabilitation Center has 500 available inmate capacity. 158 people are there, being at 32% capacity. And the Tobago Convict Prison has a capacity of 30, and there are 53 people there, as of December being 170% capacity. I felt it important to put forward the facts as to what our occupancy rate looks like, because it impacts upon where we stand as a nation if we're talking about the criminal justice system. Some of you may ask, why start with prisons? And for me, the issue is that the prison system provides a very useful pot for analysis. It is there that you can see the effect of the workings of the criminal justice system. It is there that you get to see the societal impact caused by the operations of the criminal justice system. It is there that you get to see the typologies of crimes. It is there that you get to see what the prevalence of issues look like. And so it was a useful, if not axiomatic, thing to start with the prisons and then to launch one's way into the very thorny issues of criminal justice reform, because the impact is then translated to how we as a country deal with crime and criminality. Far too often it is said that crime and criminality runs rampant because no one pays the cost. In terms of detection and conviction rates, one has a live issue right there. Trinidad and Tobago was invited to consider by Transparency International's head recently the phenomenon that can be caused by the FBF phenomenon, the fry the big fish. And we ask ourselves in our country, how many big fish have fried? How close is the concept of, if I commit a crime, that I will do the time, in terms of the rampant criminality that has gripped our country, our beloved nation, for far too long? In this particular context of the prison system, again by way of putting forward analysis, I wanted to reflect upon the fact of how our prisons housing this number of people are staffed. Because today we're going to be talking about the prisons officers, the champions of the system who do the work far often that no one else wants to do. And I thought it important to put out the fact that on a total available establishment for prisons officers positions, the establishment ought to be comprised of 4,218 persons. The number of filled positions is 2,869, giving us a 47% vacancy, with 1,349 positions vacant. Our prisons establishment is also run by prisons officers who are paid on a scale of rates. And I felt it incumbent, because I'm going to tie it into something that I'll put forward in a short while, to show the salary scale for second division officers. Not to do anything other than compare it in a cost context for an issue that I'm going to bring forward to you in a very poignant way in a short while. But suffice it to say, if one were to take just the example of Prisons Officers 1, with effect from January 2011, the salary range runs from a minimum of $6,117 to a maximum of $8,849. So that's what we pay our prisons service driver. And when you compare Prisons Officers 1, the range, which is not the driver's range, it's in fact, if you were to look at it, it's on the second to last column, row on the table. The Prisons Officers 1, the salary range is $5,882 to a maximum of $8,509. So prisons driver has a different salary range over Prisons Officers 1. And I want you to bear that range in mind. I want you to think of the 5,000 to 8,000 range, because I'm going to connect it to a particular point that I'd like you to think about in a while. We have an organizational chart for the prisons, and that organizational chart involves a management by a commissioner of prisons, this good gentleman on the stage, much like a commissioner of police. Our commissioner of prisons and our commissioner of police seem to be the sole people recognized, apart from the hardworking members of the Prisons Officers Association, but the personalities associated with everything to do with the police and everything to do with the prisons seems to reside in our country, not in an organizational structure, but instead in the personage, the personification of the Commissioner of Prisons or the Commissioner of Police. And that therefore causes Trinidad and Tobago to be removed from the fact that we have a service in operation comprised of a cadre of people who are hard-working members, but who are under some serious constraint. And we'll talk in some more bold terms about some of the constraints, not only by the panel discussion, but specifically from this podium under my watch. We have a position which speaks to governance. And it's important to note what guides the law in relation to prisons. Because there's a discussion to be had about amendment of laws. And I'd like to state at this point, the Office of the Attorney General in the last 6 months has spent a lot of time taking avail of the work that was there and the work that is required to be done. And what we have done specifically is to prepare certain legislative interventions and operational interventions, but we can't drive that in a vacuum. We wish to have a consultative approach in relation to these issues, because it's high time that the population understands the rationale for proposed amendments. Basically, you would all know, we're governed by the Prisons Act, the Prison Service Act, and the Prisons Rules. And I want you to look at the number after the words Prisons Rules, 1943. The Prisons Act gives the general perambulation as to how the prisons ought to operate. The Prison Service Act deals with the good people that organize the service itself. But the prisons rules deal with inmate conditions. And it is important to bear in mind that inmate conditions affect prisons officers as well, and inmates. And therefore, there is a ramification to be had to the extended families of prisons officers and extended families of inmates. It's multidimensional. I've taken the opportunity specifically to next deal with the types of offenses, and I want to focus on pre-trial detention. We've disaggregated remand, and I've taken all information in relation to every single prisoner incarcerated as at December 2015, and I've disaggregated the statistics which I wish to share today. Murder comprises 42% of the remand population. The remand population of the 3,000 odd incarcerated people is specifically, as at December 2015, 2,235 persons. So that's 2,235 persons in a total prison population of 3,667. Murder comprises, as a category of persons detained, 42% of that number, of 2,235. Illegal drugs, simple possession, and trafficking comprise 5% and 6% respectively. Sexual offenses comprises 7% of the incarcerated population for remand. Possession of firearms and ammunition comprises 13% of the incarcerated population. And then there's a category which you'll see on the stage, on the screen, called Other, which comprises 27%. And I wanted to share with you some of the typologies in Other versus length of time. Using obscene language, 5 years, 6 months incarcerated in remand. Failure to pay maintenance, 6 months. I'm just pulling a couple of the case examples that I came across. Breach of traffic regulations, 1 year. Malicious damage, 2 years, 3 months. I just wanted to pluck a few of what the other number of 27% looks like and to factor it back to the length of incarceration in remand. There are some typologies that affect the discussion that the panel is going to speak to, no doubt, which deals with the number of indictable criminal matters disposed of in the Court of Appeal. We've gone specifically into the courts. We've taken the Court of Appeal statistics, the High Court statistics, and the magistrate statistics, because that arena results in the production of persons for incarceration, be it in remand or be it upon conviction. And I want to put out, for the first time in a forum such as this, what some of the figures look like, what the numbers look like. In the period 2009 to 2014, the total number of criminal appeals filed from the High Court was 110. The total number of criminal appeals disposed of was higher than 110. It was 126. So that therefore speaks to the fact that the criminal court is dealing not only with the matters filed, and this isn't necessarily in order of filing, but that their disposition rate also includes matters in backlog. So we're seeing there, of 110 matters filed as a guide, the dispositions conducted, the number of criminal appeals disposed of from years 2009 to 2014 were 126. So our criminal court seems to be producing work. Mind you, this is not a specific science, but a relative reflection on the numbers makes a difference. Let's look instead now to the number of indictments filed and criminal matters disposed of at the High Court. In the period 2009 to 2014, the number of indictments filed were, in the High Court, 1,125. The number of criminal trials completed was 405. The number of criminal matters carried over was 720. And when you look at that statistical information, it means that 64% of matters are not completed over the period. This gives a bit of reflection when we see the judiciary's report every year, because you get disposal rates, you get number of matters filed, but there is a golden mystery as to what the number carried over looks like. And that number carried over is to be found, some of it, in our prisons. Hence, the remand population, and typology analysis, and disposition analysis. Let's drill away from High Court now to magistracy. The magistracy, if I can find the correct slide, yes, here we go. In the period 2009 to 2014, the magistracy, in terms of preliminary inquiries for capital offenses, and I'm dealing with subcategories here, dealt in total over that period with 582. The number of preliminary inquiries for capital offenses determined were 259. The number of preliminary inquiries for capital offenses carried over, not dealt with, was 323. And if you look at it, approximately 55% of the numbers that we've just used there. Now, I've drilled to capital matters because you will agree that when 42 to 43% of your prison population in remand deals with capital issues, you have to start looking at capital numbers. Let's deal a little bit more with figures now, and let's move to the number of non-capital offenses and look at how that stacks up in the system, and that's at the magistrate's court. When we look to the number of non-capital offenses, 2009 to 2014, the number of non-capital matters in total in that period was 118,507. The number of non-capital matters determined was 101,534. Now, I want you to bear in mind that the judiciary statistics speak to approximately 130,000 to 140,000 new matters per year in the magistracy. I have just dealt with non-capital matters there, not the entire number. Because we're looking now as a society in what our throughput looks like. And I wanted to draw the comparison between the capital analysis and the non-capital analysis. Let's look now, in putting things in context as an enabler for this discussion, to the issue of the number of judicial officers and the number of clerks of the peace for the period 2013 to 2014. Judicial officers, no doubt, you appreciate is relevant insofar as these are the single number of human beings with the capacity to determine matters. Clerks of the peace, for those who don't know, are relevant because this now determines how we deal with throughput on sureties and bail issues for persons who are sent for incarceration, for bailable matters. Court of Appeal judges, 10. High Court judges, 29. Magistrates, 57. Clerks of the peace, 12 for the whole of Trinidad and Tobago. I want to drive next to an issue of cost. And I'd like, before moving to that slide, to tell you that in an environment such as the one that is prevailing right now in Trinidad and Tobago, where productivity and efficiency are going to be the tools by which we dig ourselves out of difficult circumstances, that every single dollar matters in our country. That we become efficient, that we become productive, that there is value for money consideration. But if I were to ask this crowd right now, those listening in the future by way of the media, etc., if anybody actually knows what it costs to incarcerate a human being in our system, I doubt that anybody would have an off-the-cuff figure. There may be some estimates. How much does it cost to keep someone in remand per month? One could easily hazard a guess. But that factor can be extrapolated, and it's an exercise that we have done, because one needs only reflect upon what the cost of running the prison system is, to be found from the annual budgetary statements year on year, which speak to actual and estimate figures. But it wouldn't be as simple as just dividing that total number, the prison's cost, by the number of inmates, because you would have to factor the employment of the criminal justice system. The prosecutors exist for a purpose, be they at the DPP's office or the Trinidad and Tobago Police Service, or in the private bar by way of fiats granted by the DPP. The Legal Aid Advice and Authority deals with a cost factor which articulates with the criminal justice system. Witness protection programs have a value. Why are witnesses in witness protection? Would it surprise you to learn that in the witness protection program at present, that we have approximately, and I'll pull the figure in a moment, 240 odd people, that's associated members of families and actual witnesses in the witness protection program? Would it surprise you to know that it costs the witness protection program approximately $30 million a year to run? And would it surprise you further to learn that right now in our country, we have people in witness protection program for 13 years? So, back to the ancillary costs. What about the Defense Force? What about the Trinidad and Tobago Police Service that deals with detection and conviction? I've raised Defense Force because there are joint army patrols involved in that. What about dealing with the Forensics Institute? What about the legal aid that is granted or the law that is facilitated by the Office of the DPP itself as a whole, but what about the Ministry of the Attorney General and Legal Affairs as we now have? Now, I've said all of that before moving to the next slide because I want to drill down to some of what the figures look like. We have, and I want to jump back for a moment, budgetary allocation for fiscal year 2015 to 2016, the judiciary costs $363 million. The entire judiciary, listen to the figure, $363 odd million. I'm not complaining about the judiciary there. I'm going to give you a figure in a moment, and I want you to remember it. So we've just remembered prisons officers' salaries. The entire judiciary cost per annum, 363 odd. Ministry of National Security, $4.6 billion. Justice Protection Program, as I told you a while ago, $30 million per annum. TTPS, 3.3 odd billion dollars. Ministry of the Attorney General and Legal Affairs, merged ministry, so not quite fair to look at the full figure, $442 odd million. Legal Aid and Advisory Authority, $31 million. Office of the DPP, $23 million. Juxtapose those two figures. $30 million in witness protection, the entire DPP's office running for $23 million. The entire Legal Aid Authority running for $31 million. Let's go a little bit further in connecting the dots. Let's look now to, if I can get this slide up. I think I may have jumped. Okay, thank you for those who are assisting me. The estimated annual cost of prisons only. Now remember I told you don't focus on that figure, but let's use it for a moment. $596 million. That's for 2015, odd. Call it $597 million. Those would include, we've aggregated figures for electricity, manpower, water, food, transportation, health. The other additional costs, which I spoke to a while ago, the cost of administering the criminal justice system, judicial, prosecutorial, police servicing, witness protection. As at December 2015, remember I told you, 3,667 inmates, 2,235 on remand. If you take the prisons figure alone, the $596 million, you divide it by the total physical inmate population, you'll get $13,271.41 per head per month. But when you factor what the additional costs, which I told you are some intangibles to be drilled down to, the prosecutors, the police, the defense, etc., you can easily take that figure to $20,000 to $25,000 per head per month. Why am I putting this out into the public domain? We've been having a discussion on the prison system ad nauseum. We've been having a discussion on the criminal justice system for a very long time. We have had report after report after report in what appears to be analysis paralysis. But what does it mean for the taxpayers of Trinidad and Tobago? How much does it cost us in an environment such as this per month, per person as incarcerated? That's a real figure to be grappled with, because coming out of that comes the discussion on what are we going to do about it? And are we prepared to make some hard choices, some unpopular choices? Are we prepared to have a real discussion, not based on anecdotal information, not based upon hyperbole, but based instead upon statistically driven thoughts and analysis? So, $20,000 to $25,000 per month, per head, per inmate. But you now know how much a prisons officer earns. Remember I asked you to keep that range in mind? $5,000 to $8,000. Legal officers in the Office of the Attorney General do not get up to $25,000, legal officers 1 and 2. So they don't fall into that category either. Let's look now at what the cost of administering the criminal justice system looks like against the typologies, more particularly the number of years incarcerated. Because what we did and what we want to share today is to tell you how long people have been in the system whilst we are in analysis paralysis, and what it costs the taxpayer in that context. So, persons incarcerated for more than 10 years of the remand population, it's 11% of the remand population. Persons incarcerated for more than 5 years, but not 10 years, 19%. Persons incarcerated for 5 years or less, 70%. So I took the opportunity to extrapolate the figures for you. Not taking 25,000, not taking 14,000, using 20,000 as a median. What did we come up with? Of the persons in the category over 11 years, the estimated cost of maintaining one inmate over the length of time, that's the 11% population, per annum, for the 11 years to hold one man, one person on remand, no trial yet, pre-trial detention, $2,640,000 per person. There are 246 people that fit that category. It has costed us, ladies and gentlemen, $649,440,000 to hold 246 inmates for over 11 years. Remember I asked you to keep in mind the figure for the judiciary a short while ago? The entire judiciary's budgetary allocation is $300 million per annum. 246 inmates, $750 million. What is it for persons 5 years and over? There are 425 persons in remand for over 5 years. The annual figure for one person is $1.44 million. Extrapolate that over the number of years, 5 years, by the 425, you get $612 million. Nearly $2/3 billion. $750 million over 11 years. $2/3 billion over 5 years. Persons just under 5 years, 70% of the population. Extrapolate that number, $9.39 billion, ladies and gentlemen. I don't know if anybody's ever put these numbers in context for Trinidad and Tobago before, but I can promise you that I intend to carry out the next 52 months in this saddle, should the Prime Minister allow me to. It is, after all, a Prime Minister's prerogative to appoint ministers, but I intend to be very data specific in what we're doing. And why do I want data specificity? So that we can have real discussions. We have an office of the DPP, because we're talking about the prisons. Why would someone be in prison for that long? Trial couldn't happen. What articulates in a trial? The judge, the courtroom, the evidence, the practitioners in prosecution and defense, the accused, the transportation services, certain medical factors, forensics, witnesses. Those are some of the elemental pieces in putting the pieces together. But one of the very important elemental pieces is the office of the DPP. And I wanted to use information provided by the DPP, and in fact, which was spoken to in a Joint Select Committee recently, as a typology for analysis. So we have, in terms of positions, and I'll jump to the punchline here, of the total number of prosecutors that the DPP has available to the DPP, the establishment should have 130 persons. We have 49 positions filled. That's a 99 people absent in terms of filled positions, which is a 76% vacancy. What articulates with that? There's a process for filling. Monies have to be committed. The JLSC has to have interviews, or interviews need to be conducted otherwise, and positions have to be filled. We have a dichotomy in Trinidad and Tobago between full employment on permanent position and contract, where contract officers cannot receive the benefit of terms and conditions which they ought to have, things like travel allowance, things like a signed contract, which would allow one to go to the bank to obtain a loan or to buy a car or whatever it may be. The DPP gave a very interesting statistic, which I will just go through quickly, which was a comparison between Jamaica and Trinidad in terms of the ratios. The bottom line of that discussion really is that in Jamaica versus Trinidad, there's a ratio in Jamaica of 1 to 19, and a ratio in Trinidad and Tobago of 1 to 84. Now, what does that mean? The bottom line is 84 is several times larger than 19, so for every one lawyer as a prosecutor, the workload is the factor of how many times 19 could go into 84. So the workload of a Trinidad prosecutor is 4 times that of what Jamaica looks like. And I've done that because in Jamaica there are some very useful examples which the Office of the Attorney General is looking at in terms of typologies of courts and certain amendments to legislation which we'll come to. But I want to draw into context that there is a societal impact for all of this. The societal impact is to victims and victims' families. It is to incarcerated persons and to their families. After all, one is presumed innocent until proven guilty. It is the golden thread of the law, so recognized since 1935. Where are we now? How are trials dealt with 11 years later? How many witnesses turn up? How many witnesses are interested? How many witnesses have been intimidated? How much evidence is still able to be produced? One need only recall the fact that there were some rats that ate a whole lot of evidence once. But where was the trial without that evidence? And you know what I'm talking about. Where guns go missing, where forensics can't be found, people are just tired of the process. Do you really want to go for 11 years to talk about the rape that happened 11 years ago? When your child is now 11 years old or 15 years old or your family has recovered somewhat, do you have the guts to continue with it? And then what happens to the person who was incarcerated, rightly or wrongly? Because I showed you a little while ago some of the typologies under other. Obscene language, maintenance, simple possession. Let's have the discussion, Trinidad and Tobago. There is something called drugs. There are serious versions, and what society sometimes perceives as not serious. I take no view one way or the other, because as an enabler of legislation, as the Attorney General, anything that we do must be fact-driven and after consultation. But we have to have a discussion when you go to remand yard and you visit, as I have done, with the kind courtesy of the Commissioner of Prisons, the remand cell, which has 9 people in it, 4 of whom are in for charges of murder, and the rest of them in for possession of 2 joints of marijuana, and that they are sharing a cell for upward of 2 and 3 and 4 and 5 years, then you have to ask yourself, what are you doing inside of the prison itself in terms of recidivism or in terms of encouraging criminality through frustration? I want to have a segue into the prison service. And I'd like to explain for those panelists here that the length of time that I'm taking here is to form the springboard for the other contributions, so permit me this indulgence. Let's start to paint the elephant in the room. We have a prison service, and I want to make it absolutely clear that the prison service is manned quite properly by people who are prepared to turn up and do the job that very few people in Trinidad are willing to do. They are prepared and have been the victim of serious crime, including brazen murder in their own homes. But the elephant in the room doesn't quite look like that. And I promised my learned colleagues in the prison service, with whom I have an excellent relationship, and I want to publicly announce that the Commissioner of Prisons has been of yeoman service in our management of litigation, in our management of issues in the criminal arena, in the prison system, and I want to publicly thank him for the assistance that he has given, and to the officers of the prison service, because we've dealt with some very tough issues. One of them involves contraband. And I want to publicly speak to that issue. I would say it's not the habit of this particular administration to be too loud in the talk. People have been asking, what have you been doing for the last 6 months? We have a very vociferous opposition. But what we vowed to do was to make sure that we were doing our homework very, very well, doing the analyses well, and then coming with proposals based on data. The Ministry of National Security and the Minister of National Security himself, who is on business for Trinidad and Tobago and who could not be here, the Minister of National Security, I wish to publicly compliment and to thank as the Attorney General for assisting Trinidad and Tobago in cooperation with our offices. Because, ladies and gentlemen, just to give you an example, I went to the prison system one day. I went to the Frederick Street jail, I went to maximum security jail, I visited a number of others. But on one of the visits, I went with a very specific purpose. I went to deal with an issue of tip-off and information that I had, and which I shared with the Commissioner of Prisons, and together we did an operation. I want to tell you that this happened just after there was public announcement that nothing was found in the prisons, full searches were done, no contraband was found, and everything was A-OK. And I have the permission of my colleagues in the prison service to speak to this issue because we need to deal with this issue. I want to tell you some of the things that we found. And we found because we supervised the finding. And I want to tell you what we found, and I want to tell you that it is prisons officers that found this. So don't get me wrong when I tell you what we found. Let's start with the easy stuff. I'm not going to tell you the thousands or hundreds of items that we found, but I'm going to give you the types. We found, and this should have been last, shavers, Wi-Fi hotspots, smoking devices, earpieces, cash. See the last item there? Flat screen TV. Memory cards. Forgive me, it seems that the slide has jumped. It may be different from what I have with me. All right, no, but this one, right, there we go. Memory cards, SIM cards, headsets, razor blades, store-bought knives, as it's described, digital scales, projectiles from rounds of ammunition, that should have been pluralized, lighters, cigarettes. Let's deal with the heavier stuff, which is on another slide. Cocaine, marijuana, cell phones, chargers, and batteries. This is part of the elephant that we're talking about that stands in the room that people know about but don't speak about. And I want to tell you that we found this contraband in the bottom of the pails which prisoners use as their bathrooms, as their washing, etc. So there were false bottoms. Now, why do I say this? We found it because we didn't rely on a handheld scanner. We took the pails under instruction. We gave the instruction to take the pails and have them x-rayed at the very machines that sit there. And I insisted that we have images of every single pail. And lo and behold, what could not be found previously was sitting right there. And I'm putting forward some tough things here, because the question for everybody is, how did that get there? We have people in the jail for simple possession, for marijuana, for cocaine, and the very substance is there with them. For possession of a firearm, and a firearm under law, Section 2 of the Firearms Act, or Section 3, the definition section, says that a firearm includes the bullet or projectile. Now, I'm sure that it didn't come from the court with the prisoner, but it came in there. And I know that the Prisons Officers Association has been wrestling with this issue because they make no secret of grappling with these issues. They have been side by side with the government of Trinidad and Tobago, grappling with the issues as well, as has the Commissioner of Prisons. And again, I wish to publicly thank them for being frank and open in painting the issues and targeting them. So where are we, ladies and gentlemen, as we start this discussion? We know that the prison, as a pot for analysis, tells us the typologies of crime. It is an indicator or litmus test or rail gauge as to how our criminal justice system is functioning. But what are the solutions? What has your government been doing for you? What can you expect? Well, you can certainly expect an operationalization and a legislative approach. Because we have all the laws in Trinidad and Tobago at our fingertips, you know. The question is, do we apply them? Are they being sensibly utilized? And then there's some of them that we need to fashion to meet the specific purpose. We have electronic monitoring as a law in Trinidad and Tobago, but nobody is out of jail with an anklet or bracelet which can be monitored. the support services for it, the telecom side for it, does not exist. So what have we been doing? And I want to share with you, and I'm going to put it in terms of proposals. I can assure you that the drafting of the necessary legislative amendments have been done already, but this can't be a solo exercise of an executive or government putting it down the throats of the population or practitioners or users. It must be something that is done in a consultative approach. After all, we are a democracy. The executive has the prerogative in certain circumstances to pay the price for decisions that it makes. Because there comes a point where you have to make a tough decision that somebody else will not make. But the promise is to move us out of analysis paralysis. And in dealing with this, I wanted to share some of the initiatives that we are dealing with. It's safe to say, and I want to use the term apparent, that there is an apparent systemic failure of the criminal justice system. And of course that the evidence can be had by an analysis of the prisons. What we are doing in the Ministry of the Attorney General and Ministry of National Security is a very purposeful focus on the prison itself and on the criminal justice system itself. And now you understand why the second consultation is going to be on the criminal justice system, because it's the springboard from this one, that you move from this one into that. What we're looking at the prison system, I showed you a short while ago that we have the prison system with 32% and 20% occupancy in some prisons, and a 170% or 219% occupancy in other areas. Clearly the question is why? Is it not therefore possible, and therefore something to be done, to have the allocation system dealt with and the manpower tool at the same time? Because this can't just work in a vacuum. There has to be someone to run the system as well. But that is one thing that is at the cusp of performance right now. What are we looking at? We have to look at the capacity in the judiciary, the DPP, and the TTPS, to name a few. Because I showed you the number of judges. I showed you the number of police officers, not police officers, prisons officers. I showed you the manpower utilization in the DPP's office. But capacity, which is an operational issue, is something which a government enables. And I'm very pleased to say that we have, in the last couple of months, identified what the cost of dealing with the establishment positions looks like, because they just have to get dealt with. And therefore, filling the positions is upon us and being effected. And I'm very pleased to say that the discussions with the DPP have also coincided with discussions with the other players and, importantly, the judiciary. It was not an unimportant thing to have the JLSC perfected in terms of numbers, because you have to deal with appointments through it. And therefore, it was important to put the elemental pieces together. We have, as I spoke to a short while ago, the operationalization of certain existing laws, like the electronic monitoring, for instance. But apart from that, and I want to put it in terms of a discussion, even though I know what I want to do, what I would like to do as Attorney General, what I have prepared and have waiting, I'll put it in terms of issue only for now, because certain discussions have to be had. We have to start talking about the targeted reduction in the delays in the criminal justice system. Preliminary inquiries, ladies and gentlemen, the last government left us. The present government has 3 separate laws on preliminary inquiries, all working at the same time. But the paper transmission from a preliminary inquiry, where every indictable offense must have a preliminary inquiry, has a cost factor, and you just saw what some of that cost factor looks like. 2/3 of $1 billion, 3/4 of $1 billion, $9 billion, when you look at the analysis of what it costs you in the prison system. Specialist courts. I use Jamaica as an example, and I'll say it just that way for now, because specialist courts since the 1970s have brought a lot of relief in Jamaica, be it the gun court, be it whatever. The fact is that we need not look too far away to find certain solutions. We have the issue of competent counsel. Right now in Trinidad and Tobago, trials are aborted because counsel of choice is not available. My lawyer is X. X can't come because X is in 35 other matters at the same time, because there are not many people in the pool of criminal attorneys, persons acting in the criminal arena, and therefore trials get put off. Is it time that we insist that after 3 occasions of your counsel of choice not being available, trial ready to proceed, that you are assigned a competent counsel from a public defender's office to deal with the case? That may step on a few toes of my colleagues who I left in private practice, but I wear a different hat right now, and I would like to have a conversation about it. What about rise and sit times in the judiciary? How many of us go to the magistracy and see what it looks like after 1 o'clock? How many of us get there at 9 a.m. and see what managing a list looks like? I'm very pleased to say that through the hard work of the Rules Committee and the Chief Justice's hard work, that the criminal procedure rules are at the cusp of being fully dealt with. By certainly the time frame for implementation is estimated to be January of next year, but the draft is in circulation right now, and we have given our blessing and approval in respect of those, because managing court time is critical. What about the issue of jury trials? Now, it's not fair to say eliminating juries alone is a magic bullet. Because is it rise and sit times? Is it criminal procedure rules? Is it the fact that you can't get the evidence from forensics? Is it the unavailability of counsel? Is it that legal aid doesn't pay enough for certain matters? There are a host of other issues, but the Chief Justice has said publicly that 15 to 20% of trials are dealt with in terms of time by jury issues. The Evidence Act is prepared, ready, amendments ready to go, the conversation happening right now. How much longer are we going to have voir dires, where you put the jury out, you have a trial within a trial, because you did not record the confession statement with a video tool? You didn't record it, so you have to rely upon the information on paper and the he say, she say. I'm very pleased to announce that we have operationalized the video recording systems, and that the National Security Council has instructed and put the order in for more. But the Evidence Act has to be attenuated to allow for this to operate as well. Plea bargaining, maximum sentence, parole. Are we going happily along the route of keeping this many people at this higher cost in jail for so long? And therefore, the legislation which we have on deck right now for plea bargaining, the issue of dealing with maximum sentences, application, and parole are ready and ripe to be dealt with. Bail. How does a poor man with no land and no capacity obtain bail? Does he stay in jail for obscene language and maintenance, as we saw, as the figures show, because he can't access bail? Is it time that we start using cash deposits? And you may say, well, where does a poor man find cash? But I can tell you it's harder to find land than it is to find cash or instruments. So let's give them a fighting chance. And so that, ladies and gentlemen, is right here and right now. The establishment of a public defender's office, ladies and gentlemen, it's been talked about, it's been promised, it's been dealt with, but no one has paid attention to the institutional strengths and weaknesses of our system in a dollar value ratio. I've just showed you 9 billion plus 600 and something 100 million plus 600 and something 100 million for the typologies in remand alone far outweighs any cost that could be associated in filling the established positions or talking about public defenders' issues. Now you know the cost comparator if you don't do it. The other targeted agencies involve the prison's rules, and I want to say that we have a new prison's rule. That prison's rule, if implemented automatically right now, will result in constitutional challenges because the plant and machinery and capacity to deal with compliance with the rules has to be factored, and therefore it must be rolled out in a measured way. And I'm pleased to say that submitted before Cabinet and receiving attention right now is the appointment of an inspectorate of prisons, criteria and selection, and also the implementation of prisons rules. How many of you know that a mother that is incarcerated at present is allowed the glorious golden opportunity to see her child once a year? That's good family issues. Once a year. I'm very pleased to also put onto the public record, we came in, we met, and we're dealing with the system of the remand yard and putting a court at the remand yard because we spend a lot of money on transport. I have personally visited the site. I know the Commissioner of Prisons is there on a daily basis, and we are driving the work product. I would like to say, in terms of assisting the prisons officers, they come into Auditorium, they come under attack because they are the ones to stop, search, seize, and exercise the enforcement of discipline, to encourage a disciplined environment. And therefore, I am very pleased to say that the grabbers and jammers are working and have been implemented and unpacked from the boxes where we met them, and they're now in the system. I'm also very pleased to say that the hardline telephone system is in place so that prisoners no longer have the need, if they ever had the right, to use a cell phone, as we found, to call their family members. And so now they have the system of using the hardline monitored facility. But to assist the prisons officers, the issue of redundancy surveillance is important, where we back up the CCTVs that we have operationalized, where we store the data, and who assists the guard, the prisons officer, the soldier, the policeman, in making sure that things that are untoward are not untoward. Ladies and gentlemen, my last slide is before you. And I wanted to put it this way. Justice delayed is justice denied. We all know that. But I want to add in the reality, which I hope I've assisted you to understand. Justice delayed is very expensive in every meaning of the word, societally, financially, and otherwise. And I want to make a public commitment that this government is counting in months, that this government was certainly very much aware when it came into office that you had to have analysis and preparation, because we need to move away from the he say, she say, and start to talk facts. The reason why we must put this in the public domain is to encourage scholarship and intellectual fulmination to real issues that all of us pay for. We pay for it in terms of crime and criminality, and we pay for it from our pockets, ladies and gentlemen, something which we can ill afford. If it costs us $20,000 to $25,000 a month to keep a man incarcerated, pre-trial, how much could he have earned to assist his family outside? How many people could have received a father or mother contributing to a family setting? Because that's a lot to factor. Understand that I'm giving some pointed comments. This is designed to start a serious conversation, because on our next consultation, when the prescriptions come as to what the executive would like to do, I do hope that the population is not guessing why and listening to people who crawl out every now and then to make a comment without having contributed along the way, and hold them to account to say, well, where were you when this discussion was happening, and where are your submissions? Because it can't just be anecdotal. Ladies and gentlemen, I had the luxury of putting forward a lot of material which many of my colleagues will speak to in part. And what we intend to do is to have the various sectoral players now speak to a few other issues. We promise not to be as long as I was. Perhaps because I'm the only politician on the stage, one could expect a politician to speak a little while longer, but I thank you for your indulgence, and I ask you to first bring, by way of introduction, the very good office and holder of office, Mr. Sterling Brian Stewart, who's our Commissioner of Prisons, known to you all as the first contributor this afternoon, following the staging of the issues on this particular topic. Thank you very much, ladies and gentlemen. Lest I be incarcerated, the Commissioner of Prisons has asked me that he not speak first just yet because he'd like to facilitate instead Mr. Daniel Khan as the Inspectorate of Prisons. And one can see the logic behind that because then he would get to reply to both of the issues. So ladies and gentlemen, Mr. Daniel Khan is an attorney well known to Trinidad and Tobago, both in terms of his practice and ability. He is currently the only person serving as Inspector of Prisons under the laws of Trinidad and Tobago. And for those of you who have not read his sterling report on the state and condition of our prisons, I invite you to do so because it is mandatory reading. May I welcome Mr. Daniel Khan with your assistance to the podium.